webinar so that it is made available to you after this. If you want to refer to it, we'll be sending out an email after the webinar, shortly thereafter the webinar, with a link to it once we get it uploaded onto our site, as well as with some other information that we're going to be giving to you towards the end of this webinar. At the bottom of your screen, or where your Zoom window is, you'll see that there's an opportunity there to either chat or a Q&A. In either the Q&A or the chat, we prefer the Q&A certainly, but in either the Q&A or the chat, if anywhere along the way you have a question, put it in there. Colin on my team, he's listening in on this. And at the end of this, anything you put in there, any questions you ask, I'm happy to answer those questions. This webinar should take anywhere from 30 to 40 minutes, depending on the cadence of it and depending on how many questions there are at the end. Okay, let's jump right in, shall we? So this is part of our Selling Security series. I realize this is somewhat off topic relative to selling security in what our series is all about, but that notwithstanding, because the California Consumer Privacy Act has a very specific element of cybersecurity protection and compliance, it fits right in with the various topics that we've been speaking on during our bi-weekly series. If you're not registered for our bi-weekly series, I certainly encourage you to do that. Links to that will also be made available at the end of this by way of email to you. Generally, what we're going to cover today is the California Consumer Privacy Act, rights, obligations, exemptions, etc. What you can do and how you can prepare for the opportunities that it's presenting in front of you today. The law was passed last year. It goes into effect January 1 of next year. We are a little shy of 9 months away from that. It's generally in its final form, though between now, it does have one amendment already to it that was completed, and that's included in here. And there's another amendment that's making its way through the California legislature that will further amend it if, in fact, it passes. It has much broader aspects to it and further enhances the consumer's rights under the Privacy Act, and therefore makes the obligations on businesses even more onerous. They're not necessarily terrible, and we're going to get into that, but when you start to add some of the things that are going through the amendment process today, those things that are coming down the pipe, if they were to pass, would be significantly onerous. But the opportunity that's out there today is a significant one. And when people talk about the Privacy Act, they think about it just in terms of privacy and how you protect PII, and that is absolutely a component of this. But what makes this such a significant regulation is that it empowers the consumer with a right to action. What does that mean? That means that the consumer has the ability to go after the business if they haven't adequately protected the data. That has not necessarily been the case in the past. Not only was it difficult because there was some shield laws to businesses, but it's also been difficult because you had to prove harm, which is always difficult to prove. Under this particular reg, there is no obligation to prove harm to seek compensation on behalf of a consumer. And then again, at the end of this, there'll be a Q&A. So again, at the bottom, put your Q&A in the Q&A section or the chat section at the bottom of your screen, and Colin will read those back to me at the end of this. So this is a running theme in our Selling Security series. We want you to think bigger. What does that mean? All too often, MSPs, MSSPs, IT solution providers, they think with a product mindset. We're going to buy the best antivirus, the best firewall, the best network level monitoring. We're going to subscribe to the best training, etc. And that's terrific. I'm sure you guys do a great job in the product suites you assemble. The problem with that is when you think about selling by way of product, you're not thinking big, and you're providing the opportunity for the competition to compare you by price on a product by product basis. And so when we talk about thinking bigger, we want you to think about delivering a solution, not a product. Because no one's going to walk in there and say, yeah, my product stinks compared to theirs, but we're great guys. And the minute you go in and start telling everybody how their product stinks, what you're really doing is telling them that they made a poor decision in the past. And we certainly don't want to go into prospects and businesses telling them what a bad job they've done. And so when you sell solutions, you're selling something completely different. You're selling something much bigger than a product. And you're selling something that people can't necessarily compare you against on a price basis, because your solution may or may not include everything that they include. And frankly, most people don't sell by solution. And solutions are really the best way to go. I love when I sell against somebody who's offering products, because when they're offering products, I can tell you all day long why our solutions are better. And when they add up all those products, they'll frequently find that there's a big serious gap in their security posture. So we want you to think bigger. Think about selling solutions. And as we talk about CCPA, the California Consumer Privacy Act, think about the solution stack, not the security stack, because that gets you thinking about products. The solution stack that you've built and how you're going to satisfy the regulation for them and drive value for them. So the California Consumer Privacy Act, as I said, is a much bigger act than traditional acts of privacy in the past. In fact, it's significantly more broad than GDPR, the European Union General Data Protection Regulation. And everybody thought that was a big deal. This is a much bigger deal. And the reason why this is a much bigger deal is because for the first time, any business that does business in California, so your client doesn't have to necessarily be a California business, they just have to be selling to a California consumer, because this is a Consumer Empowerment Act. And so, for instance, we've got partners who actually have businesses who do a lot of business in California, and they're domiciled, headquartered, located in Texas and Michigan, et cetera. And so as long as they're doing business with a California resident, they're obligated to comply with this regulation. And this regulation, as I said, empowers the consumer with certain rights that they hadn't previously had before. And those rights create demands on the owners, the business owners, and the businesses with whom they transact. The first demand it places on them is they have a right to know. They have a right to know what is being collected in terms of their information, whether it's name, address, social, it doesn't particularly matter. And believe it or not, in this instance of the regulation, for the first time ever, address is considered personal information. As ridiculous as that is, because it's in a phone book. But I'm going to explain why in a moment. So they have a right to know what is being collected. They also have a right to know how it is being collected and used. So how are you gathering that data? Whether you're gathering from the websites, whether you're cultivating it through the SEO platform and program that you've put together, whether you're using some enticement to induce them to give up their information, perhaps they're doing house charges, so they're offering in-store gift cards, whatever they do to collect information, the consumer has a right to know how it's being collected. And they also have a right to know to whom it is being sold or disclosed to. Two very distinctly different things. Because a business can sell their data to somebody else, or they can disclose it to somebody else. And by what I mean by way of disclosure is, for instance, when they give the information perhaps to their mailing house to send out newsletters. Or if they give the information and upload it into Constant Contact or some other platform, once they've given out the information beyond the four corners of their business to another entity, a third party as it's known, they've disclosed the information. And the consumer has a right to know this. So the first thing the reg did was empower the consumer with the right to knowledge. The second thing they've empowered the consumer with is the ability to prevent the use of that information beyond the transactional need. And what I mean by that is that if you need the consumer's name and address and phone number to complete an order, for instance, you're going to ship something to them, and I don't mean you, I mean your customer. And I apologize for saying you. So if your customer needs that because they're collecting name, address, phone number to ship something, they need the information for the transaction. But once the transaction's over, the business doesn't necessarily have a right to keep it unless two things are true. One, they've informed the consumer that they're keeping it, that what is being collected, and the consumer has the right to say, I don't want you to keep it anymore, and they must delete it. In fact, they must also delete it from any third party they've given it to, and I'll come back to that in a moment. And the other thing that it's empowered them to do is ask for you to delete it, as I said a moment ago. So they have a right of removal, a right of knowledge, a right of sale, and a right of removal. Now, some of this is not necessarily unique to CCPA. The broad structure of it is not unique. The elements of it are. Some elements of it are. But the real teeth in this regulation, which is where other regulations fall down and frequently don't get much traction in market. If you think about HIPAA for a moment, every doctor, everybody who practices medicine is obligated to HIPAA, but almost none of the practitioners employ some sort of HIPAA set of controls in their organization because it's too onerous and the federal government never comes a-looking. And so because there's no technical teeth in HIPAA, nobody really employs it except the big healthcare institutions, or unless they've been caught, fined, and then they'll implement. With the right of action, California has empowered consumers the right to collect money if businesses don't comply with their request. So they have a right to know. If they don't comply, they can collect money. They have a right to opt out. They have a right to request it be deleted and ensure that it has been deleted. And through these rights and this right of action, they have recourse if businesses don't follow through. And that right of action is what gives this regulation teeth. From a business's perspective, the onus is on them. And so they are obligated to notify the public. So it's not good enough that the law is passed and the consumer has the right. The law is demanding that businesses tell the consumers what their rights are. And I'm not casting judgment on whether I think this is right or wrong. These are just the way these are just the manners in which this law is constructed. So businesses must go out there and publicly notify the consumer of what these rights are. And they have to notice it publicly, and they have to make it available upon request. So if a consumer, if a consumer walks up to the counter and says, what are my rights under this privacy law? The business has to provide them with what those rights are. Now, it doesn't dictate it actually has to be in a formal document, but somebody better be able to provide that what those rights are. Better to write it down than not. Strongly encourage our MSSPs and our MSP partners to have a document similar to that. We have those for our partners, but that notwithstanding, you're going to want to have something uniform that's being handed out, or your clients are. You're going to want to make sure that they do, because you want to make sure that the message is crystal clear and it comports with the law. The other thing that your client businesses have to do is provide a mechanism for the consumer to opt out, not allowing you to sell that information or share it with somebody else. And that opt-out mechanism is executed in two ways. One of them is it has to be a very simple, easy, and straightforward process for the consumer experience. And so if the consumer shows up at your client's office and says, I want you to stop selling it, what do I have to do? It has to be very simple for them to follow. Whether it's something as simple as fill out this form and hand it to somebody, the directions need to be crystal clear, or whether or not they have something on their website, which they have to have on their website, but the business says, let's go to the website and do this. And in fact, there's actually language in the law that says there needs to be a link on the website that says, quote unquote, do not sell my personal information. And they actually have that language specifically like that in the law. And so there must be a process in place for the business to follow that the consumer can make sure is executed. And there has to be a way for them to online easily opt out, and that needs to be connected to that process. It has to be fully auditable too. So you have to be able to demonstrate that it has been done because they have a right to know. And that right to know includes the auditability of that transaction. And then finally, they need to be notified of these rights, as we said earlier, but what the right of removal is, what the notification of process looks like. So again, how is it you're going to go about removing me? How is it you're going to use and share and sell my data? All of these things they have a right to know. And that removal process is included in that. They also have a right to have their data, as I said earlier, removed from a third-party system, and they have a right to know that you've confirmed, not you, but that your client has confirmed that it's been removed, that there's been a third-party audit done, if you would, so that your client and their third party, so think for a moment, if you would, about them using a mail house to send newsletters. They need a mechanism. You can develop that mechanism for them, certainly. They need a mechanism by which to ensure the mail house has deleted the data, because the business is obligated to show the consumer that you told them and they did it, that your business told them and they did it. And so this is where the onus is on the business. I know it doesn't sound like a lot, but they're already busy conducting the day-to-day business. This is a significantly onerous burden, both in terms of developing processes and language and forms and other things, but also training their staff to make sure that if a consumer walks through the door and asks these questions, these are the things that you must do as a business owner to ensure that's done. And not only just put it down once, but go back in there and audit and confirm that your employees, Mr. Business Owner or Mrs. Business Owner, are actually executing. So you're auditing the process because you also have to prove to the consumer that you're doing that. Again, that's the way this regulation is constructed. Okay, there are exceptions and exemptions to the regulation. So this isn't every single business is obligated to do this. Well, every single business that does business in California. Again, you don't have to be domiciled in California to do business in California. But if you do business in California, you're obligated to this regulation. So the exemptions and exceptions that exist, if you're a nonprofit, this regulation doesn't apply to you yet. If you're a business who earns less than $25 million in annual sales, you're also exempt. If you get less than half of your annual revenue from selling personal information, literally selling it, not just using it, then that business is also exempt. And then finally, with a buy, sell, or share, I'm highlighting that word because it's germane now, information on less than 50,000 individuals, households, and devices. So this is where this regulation has gone beyond the normal confines of privacy reg and really makes this a serious burden on actually more than half the businesses in California. You wouldn't think that a small business would necessarily reach 50,000 records of individuals, and most certainly they might not. But now they're talking about households and devices. And utilizing this word, extending this word, the privacy, to the word household, creates a very unique identifier, not heretofore seen in privacy reg, where just a simple address becomes private information. And so anything that can identify a household you've done business with. So think about current resident at, those mailings we all get. That at, if the current resident at doesn't mean anything. The address, however, is now a unique identifier under this regulation. And devices. This is another piece of the reg that really extends the burden so broadly that it's very easy to get to 50,000. What do I mean by that? So for instance, more than 53% of the businesses in California, or 53% of the businesses that do business in California, use some sort of SEO to drive traffic to their site. Every single piece of traffic that hits their site has a device identifier attached to it. Under this regulation, that is personally identifiable information and is one of the 50,000 times they have to get before they meet the regulation and then have to comply. But you see how quickly that scales. So if 100 people a day traffic the site, and they trafficked it from their mobile device, from their office computer, from their home computer, every one of them is a unique device identifier. Plus whatever traffic that's coming across transitionally and as a transient, if you would, to the website. Plus where every time the website shows up in a search, because the search engines to which your businesses have subscribed, your clients' businesses have subscribed, are tracking the devices that ran the searches. And so each and every one of those instances creates a unique device identifier that further chips away at this 50,000 minimum. And this is in a year. And so you very quickly get to 50,000 between devices, households, and individuals. Very quickly. You get to 50,000. And you can see why then so many businesses are impacted. If it was just 25 million, if it was just less than half of your revenue, but this 50,000, when it includes households and devices, it gets to scale very, very quickly. And this is what the market size looks like in terms of the opportunity. So now we're talking about opportunity. This is what the market size relative to California consumers and the businesses that do business with them. This is how big that market is. There's roughly 7.5 million businesses servicing California residents today. That's in-state and out-of-state companies that do business in California. On average, there are 6 members of a business's supply chain. These are individual third parties to whom information is shared about the transaction, about the individual. So these 6 supply chain members are third parties that you must, not you, but your business must, but you can do for them. This is the opportunity that you can track for them to make sure that when they receive personal information, that your client is notified what to do with it, and that when the consumer requests deletion, that you can confirm on their behalf that it's in fact deleted. So the supply chain extends this concept of 7.5 million businesses times 6. And so you've got somewhere in a magnitude of 38 million different transactional opportunities where data, when requested to be removed, has to be removed. There's 11.5 million households, 39.5 million residents. 53% of them do. 53% of the businesses use SEO. We talked about that a little bit earlier. 92% of the individuals shop online. So this comes back to this concept of device tracking, device IDs as a unique identifier, and quickly getting up to that 50,000 mark. And on average, an individual has 8 different devices they use. And these numbers come from a variety of agencies and small business organizations. So these numbers are some of the stats. I do have a footnote to reference where they come from that I'll make sure that is sent to you as well. Effectively, almost 100% of all businesses who do business in California collect some sort of personal information under this regulation. And therefore, almost every single business in California is impacted, and therefore an opportunity for you to help them solve the problem that they have with this new regulation. As of right now, approximately 4 million businesses are obligated under the California Consumer Privacy Act. And this is what the market looks like. And again, it has teeth because of the penalties. And the penalties are twofold. The state, by way of the Attorney General, has a right to fine businesses. So in a simple form, they can fine up to $2,500 for an unintentional violation and up to $7,500 for a failure to protect. So they haven't put in safeguards to make sure that there is no data loss, encryption, advanced endpoint protection, next-gen endpoint protection, firewalls, mechanisms to ensure that third parties are also protecting the data, mechanisms to make sure that third parties are deleting that data when requested, making sure that they delete data when they're requested. And failure to protect raises that fine, as I said, up to $7,500. However, the business has an opportunity to cure, which means once they're notified by the Attorney General that there's a violation pending, they have an opportunity to cure that within 30 days, and then the fine will not be levied. However, imparting these kinds of measures of protection, ensuring that the supply chain is deleting data, getting out notifications and all the other things is darn near impossible in 30 days. Leaving that alone for a second, if there's been a breach and the data has gotten out, you couldn't possibly claw back that data in 30 days, if you could at all. And so you will almost certainly see these fines leveled, and that 30-day cure period goes away if there's been a breach. And so breach protection is definitely a significant component of this because they've actually written this into the regulation. Under the consumer right of action, we talked about this earlier. So the state can fine you, but now the consumers also have a right to action, right to go after the business to ensure that they are complying with the law. And we talked about these things. An element of that regulation, as I said, the right to action is that the information is subject, and quote unquote, this is coming directly from the reg, subject to unauthorized access and exfiltration, theft or disclosure, et cetera, because they failed to maintain reasonable security procedures and practices. Procedures and practices. And that is a very interesting phraseology because it implies several layers of protection inherently. So it's implying security awareness training. It's implying endpoint and perimeter protection. It's implying refreshers. It's implying simulated phishing. It implies a lot. And it becomes up to the business to defend itself in court that those measures were adequate and best practices because of the consumer's right to action. And the interesting aspect of these fines is the consumer doesn't even have to prove that they were harmed. So imagine, if you would, for a moment, that one of your clients' businesses were breached, God forbid, and some California consumers' data was exfiltrated as a result of that breach, or or they think it was exfiltrated during that breach. They have a right to sue. And even though nothing happened to them, even though their credit rating didn't change, even though nobody stole their identity, they will receive some degree of reward because they don't have to prove harm. Certainly, if they can prove harm, the reward is much higher. It's in fact limitless if they have not maintained reasonable security procedures and practices. And one of the real serious elements of teeth in this regulation is the fact that they can join a class action suit. Why is this relevant? It's relevant because no longer are the businesses going to rely on the consumer's right to know. They're going to remember, they're going to do it, and someone's going to go hire a lawyer. This, by way of regulation, by language in the regulation, says they can join a class action, and you're going to see a flood of attorneys move into the space and start signing up individuals who may not have been harmed, but once a client's business has been breached, they are subject to at least prove that they maintain best practices, reasonable standards, security procedures, etc. And so by enjoining the class action language in the regulation, they open the floodgates for lawyers to walk in and become the consumer advocates. Not saying it's bad or good, but no longer is the onus on the consumer to initiate the action. A lawyer, and we've seen the commercials all over TV in every state in the union, there's always a lawyer saying, if you've been harmed by, if you've been wounded by, if you use this device. Those are lawyers gathering up, quote unquote, victims to join them in a class action suit. And so the lawyers are going to become their advocates. And more than fines, they can also use injunctive relief, meaning preventing them from continuing the practices until such time as the suit is settled. And so this is a very serious component of the reg, and something that creates a fierce urgency of now. Businesses must do something today. And you, as an MSP and MSSP, when you assemble a solution stack, you can provide a solution set that helps mitigate this on their behalf. You have less than 9 months and counting. Businesses must be prepared. Again, they have to create public notification, privacy, and the privacy policies and their rights. They have to develop internal controls, because remember, they have to make sure they're notifying everybody in the same manner. They have to make sure they are notifying everybody. They have to make sure third parties who collect data are protecting data. They have to make sure when third parties have to delete data, they delete data, that they delete data on their own, et cetera, et cetera, et cetera. And so they need a series of internal controls to ensure that they and their third parties are following the law. And they have to be able to prove that and disclose that information, because the consumers have a right to know. They have to have a set of policies and procedures that include a variety of things, security-centric practices, along with the on-demand notification. What happens when someone says, tell me my rights? What happens when someone asks, how do I know how you delete it? How do you use it, etc. So they need policies and procedures around all that. That's also followed on by audit to make sure. And they need a mechanism to claw back data from third parties they've given that information to. Because remember, it's not just buy or sell, it's also share. And they share it with their supply chain vendors. So again, if they're delivering a product and they send that information off to UPS, guess what? That's a supply chain vendor. And so you have to the business has to make sure that supply chain also removes the data. I can't stress the importance of that enough. So that third-party clawback policy of the data is an absolute must, and it has to include accountability and audit. They also, language in the regulation specifically states that they have to update their front-facing electronic portals, their websites. Whether or not their website does any kind of e-commerce is irrelevant. The website has to have on it an easy way to opt out. The language in the reg actually says, it should say, do not sell my personal information. And it's got to be a link that executes the process and policies that they developed. If they're going to have a clawback policy, they need to map the personal information that they share to the chain of custody of everyone who's touched it, so that they know who's touched it, because remember, the consumer has a right to know. And they also have to know who's touched it when they're going to claw it back and make sure it's been deleted. So they need to understand the chain of custody, which is a terrific opportunity. They have to demonstrate how they protect personal information, so the layers of security that go around it. They have to monitor that protection. They have to audit that protection. All of this they have to monitor and audit. And so these are the things that businesses who do business with California consumers have to start working on today, have to implement by Jan 1. And if you look at this list, you know, if you've ever done any kind of significant rollout, this is not a 1 day, 1 week, 1 month process. Just to pop the process of developing policies and procedures is a many month process that not only requires some understanding of the organism that is the business, but then going out there and educating the stakeholders in what goes on. And that is a tremendous opportunity, because many of them don't do it today, don't understand the regulation, don't even know where to begin. And so you have an opportunity to help. You can do something today, tomorrow, next month, the next several months, the next 9 months until launch. And first and foremost, you're going to want to start with a risk assessment. You want to evaluate, what does the risk landscape look like relative to the organization, consumers' private information, the third parties that touch it, all of the various stakeholders in the chain of custody, what the environment looks like. You're going to want to do a technology audit and a vulnerability scan as well. And you're going to want to do this very wide-reaching, very deep assessment of what the risk landscape looks like for that organization relative to personally identifiable information, PII or PI as it's known in the reg. You're going to want to look at their policy set as part of the risk assessment and develop a set of policies and procedures that create cultural norms that comport with the regulation. And what I mean by that is the policies and procedures that teach the employees, the staff, the company how to interact with the consumer with this regulation. Their right to know, their right to remove, their right to delete, their right to action. You're going to want to implement protective layers. These are typically a technology blanket where you impart the next gen endpoint protection, the managed firewall or firewall with UTM, subscription services, spam filtering, web and DNS, all of the elements of the technological solution that create a security blanket around the business. And then you're also going to want to employ things that reset the culture, because ultimately the biggest hole in the security posture is not the endpoints, the workstation servers, but the human endpoint. That is the point at which 92 or 3%, I don't remember the number exactly, of all breaches happen as a result of human error, unintentional or intentionally. And so you want to reset that culture through security awareness training, simulated phishing, policy and procedure implementation, and audit with escalation, et cetera. And so you want to reset the culture, help them reset the culture. You want to monitor the technological blanket, the chain of custody. You also want to monitor that cultural change. And you can do that using our portal, a variety of other portals that are available to you, because all of these things speak to the security posture of the organization, and you're going to want to help them audit so that they are in fact confirming compliance. Because remember, the right to know also is a right to know whether or not they're in compliance, and so a consumer can ask for that. And so these are the opportunities that are at your fingertips, that are laying at your feet to go out there and help the some 4 million businesses that do business in California. And this is where MSPs become MSPs, and MSSPs are trusted advisors, solution providers that mitigate the burdens put upon the businesses for whatever reason. In this case, it's the CCPA. Maybe it's the burden of being hacked, whatever the case may be, it doesn't matter. So that you become their trusted advisor, helping them to mitigate the burden. Relative to CyberGuard 360, we've got 2 different platforms to help solve for this. One of those is our PII Guard 360 platform. This is our breach prevention platform. And in PII Guard 360, you get a NIST-based risk assessment. It's a Q&A and yes, no, not applicable type Q&A. You get over 40 policies and procedures, some of which directly apply to the CCPA. We include security awareness training today. We will be including in the next few months simulated phishing, dark web monitoring search, and we're working on that vendor clearinghouse, this capability, if you would, to make sure that you know everybody in the chain of custody. And therefore, you have the ability to go in there and audit them, audit their protective measures, other opportunities for you as an MSSP, and then also provides the mechanism for requesting clawback and things like that. So PII Guard takes care of that human endpoint, because in the policies and procedures component of PII Guard, not only would all the policies and procedures be there, but it's a full audit trail of who's attested to it. So you know every team member in the business that went in there and read the policies and procedures and attested to it. The audit trail of the security awareness training, the refresher emails that they get. Did they open them? Did they watch them? Things like that. Because the right to know demands this consumer know whether or not the business is protecting their PI. Our other platform we also offer is CyberGlass, which is our SIM 2.0, SIM Security Information and Event Management. We're not dissimilar to other SIMs where we monitor the threat landscape and the protective layer, but we also include several elements, if not all of the elements of the protective layer. So included with CyberGlass, along with the SIM that monitors monitors the threat landscape and monitors the attack surface, we include next-gen endpoint protection. We include network level monitoring. We have our own patent-pending risk score, CyberGlass AI. We're a see something, do something platform. I don't want to go belabor these. I'm happy to do a demo in a different time, but CyberGlass AI in conjunction with CyberGlass, the SIM, provide you the ability to monitor, audit, and because of all the includes, you have that protective layer as well. We are adding to that the Employee Vulnerability Index. We get that information from our sister product, PII Guard 360, where we know whether or not employees have done security awareness training, whether or not they've opened the refresher emails, whether or not they've fallen victim to a simulated phishing attack, whether or not their email is on the dark web. And so we have an Employee Vulnerability Index, and we also are working on adding the dark web exposure to CyberGlass. So why CyberGuard? We talked about CyberGlass SIM. We talked about PII Guard 360. We do offer free migration of your current endpoint protection because we do include it. You don't need to use it if you don't want to, but it does come with the product. We will also include PII Guard for every client you put on CyberGlass. You get PII Guard for that client as well. PII Guard is available as a standalone product too if you wanted it. That's entirely possible. And if you currently use another breach prevention platform like BSN, we'll migrate your data for free. We also offer done-for-you risk assessment. Some people are not very familiar at all with how to do a NIST-based risk assessment. And so we'll do that for you in your name. The only component of the risk assessment we will not do is the on-site verification, if that's something you plan to include. And we strongly encourage you to do that because on-site verification is a terrific value add, but not a necessity, so to speak. And then we do done-for-you firewalls. So we will actually pre-configure and ship firewalls for you once you tell us the relevant network information that would have to go into it. And it also comes pre-configured to talk to CyberGlass. Okay. I am ready for Q&A. Let me see. I think there's a few out there. Colin, is there anything out there? We'll do that. I'll leave the resource page up for a moment. And again, this is going to be sent to you by way of email. So if you're interested in the summary of the law and its impact, I actually wrote a blog on it on my site, so you can take a look at that link. Text the law, some other things there. You don't need to write this down again. Colin's going to send this to you by way of email. I'm going to leave my contact information up here while Colin tells me if there are any questions and what they are.
Yes, there have been a combined 4 questions so far from the Q&A and chat combined. First question, I'll just go in order when submitted. I've built my security stack around products using GMS and other portals. Is it enough of a solution just to add risk assessments, awareness training to my current stack?
So the way I hear that question, is it enough? The question is, are you able to really apply a full security blanket that fully monitors that you have daylight into? And the way that question was posed tells me not really. Not because you're not capable. Certainly that's not what I'm implying. It's because it doesn't sound like an orchestrated solution. Right? Because ultimately, if you're using individual siloed products, you are relying on the human element. Again, the largest point of failure in every enterprise is the human endpoint, even in our own enterprises. And so every time you stand up another interface, another product's SIM, let's call it. GMS is a SIM, by the way. So GMS is a SIM for sonic wall firewalls, right? And so you've got one interface that you're looking at the threat landscape. Maybe you're using a different NetGen product and you're looking at that interface for what's happening on the endpoint security. And then you're looking at a dark web portal, and then you're looking at a web DNS portal, and then you're looking at every time you introduce another element to monitor, manage, and manipulate, you are adding an opportunity for the human endpoint to fail. And we're human, we fail. And so, is it enough of a solution? In my opinion, no. Because the moment you introduce the human element, every time you introduce the human element, you create opportunities for failure. So orchestrated solutions are always the better choice. I talked about solutions early on. I love selling solutions. I would love to go against somebody who stood up individual products because I can give you 100 reasons why when it's an unorchestrated one, forgetting about the human endpoint for a moment, when it's an unorchestrated security stack, one piece of the stack doesn't know what the other piece of the stack is doing. So I would say, no, it's not enough. And not just because we sell an orchestrated solution. We sell an orchestrated solution because we actually believe what I just said. Okay?
All right, next question. If most of my clients are less than 25 million in sales annually, should I still prepare to start selling a new solution? I remember you recalled the combination of that and the 50,000 data points.
So the answer is yes, and the reason I say yes to that is, let me just jump back to this graphic for a second, is right there. Right. So again, for a moment, let me just go back one more. So there are less than 25 million. They make half their revenue. They make less than half their revenue from selling the information. The problem is that are there more than 50,000 individual pieces of individual devices, household, and or individuals? And I would argue yes, because if you look at the stats again, the stats here, the average person has 8 devices. So if a consumer lands inside an office, or lands inside a business, or lands on a website, there are at least 2 or 3 opportunities on their device, and at least themselves. And if they've given up their address, then there's their household. So just in that one scenario, you've got that one person has created 3 to 5 different unique PII identifiers. And so at scale, that's what you're talking about. And if you look at these numbers on the screen, 7.5 million businesses, top left corner, 7.5 million businesses service California residents, 4 million are obligated by the stats. So much more than half the businesses in California are obligated under this regulation. So I would say absolutely that's something you need to be looking at, because short of doing a due diligence on all of their front-facing properties, so their storefront, their website, their Twitter feed, again, all of these things I'm talking about, by the way, capture device information, which speak to that 50,000 number. The Facebook page, the Instagram account, where information is being gathered by a third party, by the way, information is being gathered, you quickly get to 50,000. You don't need a lot of physical people to get to 50,000 pieces of identifiable information. And so I would say, yes, you do.
All right, third question out of 4. If my client complies with HIPAA, will she automatically be CCPA compliant? If not, what are the missing areas?
So no, because HIPAA is not nearly, first of all, HIPAA is a federal reg. I'm sure everybody knows that, but I just wanted to clarify this. Because with HIPAA doesn't consider an address or a device identifier as PII. And so by definition, you are not necessarily covering those elements, and therefore you don't necessarily know if you've reached that threshold. So that's first and foremost. Secondarily, the expanse of the regulation, the right to know, is markedly different under HIPAA than it is under CCPA. And so if they don't have the policies and procedures in place by which to inform, remember, knowledge is one of those rights, by which to inform the California consumer, then they are not compliant with the regulation. The good news is that if they're actually following HIPAA, they are compliant with significant components of the regulation, so that's good news. And if you're already doing that for them, you've already assembled a good, I assume you've assembled a good stack for that. Hopefully it's a solution-based stack and not a product-based stack. But there are still areas of the reg that are exposed as a result of HIPAA falling short. I'm not saying, again, that it's negative, but just falling short because under CCPA, household and address is a unique identifier. The right to know is completely different. The right to action is also completely different.
All right, the last question, and this came in from a friendly MSP that we know in Canada. She had asked, how are we, CyberGuard, thinking about or approaching the CCPA and the expanded definitions of PII?
Good question. And so we have, through our platforms, I'll overtalk those here. So through our platforms, we're already addressing that. Our PII Guard 360, our breach prevention platforms, we already have some and are working on the balance of the policies and procedures to administer notification for the businesses that subscribe to that. And so they're going to have a set of policy and procedure templates that obviously you're going to want to customize for the business that you're using it for. We're also providing some opportunities to update the front-facing properties. So whether it's the website or other things, signage and other things, we're going to provide that for you to provide for your businesses as well. So first and foremost, the PII Guard 360 breach prevention platform is going to have all of the components of the policy and procedures by way of template, again, because you're going to customize those for your business clients in there for you to use and leverage. When we get this vendor clearinghouse stood up, that's also going to be made available to you. On the SIM side, on the Cyberglass side, because that's an orchestrated solution, and because it includes the protective elements, the technological elements, so it includes the next-gen endpoint protection, it includes network-level monitoring, it includes DNS and web filtering, it includes other components of the technological envelope. As an orchestrated solution, it is already meeting the technological security blanket for breach prevention. And so that's the way our platforms facilitate satisfaction under the regulation. As all of those items that are in waiting, so the ones that we're working on, like here, if you look at the bottom, the two that are italicized, that is the Employee Vulnerability Index and the dark web exposure. Those are components that are being added to, in this case, Cyberglass a little bit later this year before the reg goes live. Here in PII Guard, the simulated phishing, the dark web monitoring, and the vendor clearinghouse, these elements are being added a little bit further downstream before the January go live. So that's what we're doing to ensure our goal with CyberGuard 360 and our platforms, Cyberglass and PII Guard 360, are to give you an MSSP in a box, give you a done-for-you MSSP solution that you can literally bolt onto your practice and provide compliance for your clients. It does require some fine-tuning by you. As I said, you're going to want to edit the policies and procedures on a per client basis because a client's organization is different from their neighbors. And so you want to craft those around their culture, but that's the value proposition you bring to the table. This is not a set it and forget it, because MSSP services by definition are the trusted advisor services. So I hope that made sense.
All right, that's it. Just some questions about our product and pricing, which I'll follow up with those people after this webinar.
Terrific. Well, let me get my information back on the screen. If you guys want to reach out to me directly, that is perfectly fine. My email address and phone number are up there. Happy to show you anything. Happy to talk to you about anything. Happy to answer any questions, even if you don't buy. If you just have any question whatsoever, feel free to reach out to me. I am always available. Colin will send around some information relative to the links, as well as my contact information. I hope everybody has a great day.